Resuming debate, the honourable member for Niagara Centre.
Well, thank you, Mr. Speaker. I am, in fact, pleased to speak today on Bill C-51, an act to amend the Criminal Code and the Department of Justice Act, and to make consequential amendments to another act. This bill, Mr. Speaker, proposes to make various changes to the Criminal Code that seek to make the criminal law modern, relevant, and consistent with the applicable charter case law. Mr. Speaker, it would also make important clarifications to the law of sexual assault. The Justice and Human Rights Committee has now concluded its study on the bill. The committee heard from a number of important witnesses and stakeholders representing diverse viewpoints. In particular, witnesses were most interested in sharing their perspectives and recommendations with the committee members on issues relating to the proposed sexual assault reforms. Mr. Speaker, the committee considered a number of amendments to those proposed reforms and adopted two that responded to what they heard from the many witnesses and that seek to bring even greater clarity to the law. The committee also heard from witnesses in relation to the proposed repeal of an offense that targets disrupting religious officiants and ceremonies. The bill proposed to repeal this offense because, Mr. Speaker, to the degree that it prohibits conduct that merits the criminal sanction, it is, in fact, duplication of other more general offenses. During the study, Mr. Speaker, of Bill C-51 at the Standing Committee on Justice and Human Rights, committee members also heard from witnesses and constituents who were, in fact, concerned about the proposed repeal of Section 176, as mentioned earlier by one of my colleagues. Our government listened to these concerns. Liberal MP and committee member from West Nova put forward an amendment to retain and modernize the section to ensure it is, in fact, gender neutral, and make clear that the section applies to all religious and spiritual faiths. The government supports this amendment. We believe that all Canadians, regardless of which religious or spiritual faith they adhere to, must be able to practice that faith without fear of violence or disturbance. Mr. Speaker, there are other proposed amendments contained in Bill C-51 that may not garner as much attention, but which are nonetheless very important to the proper functioning of our criminal law and to the overall coherence of the criminal code. For instance, Bill C-51 proposes to amend a large number of offenses by removing what is called a reverse onus. Mr. Speaker, a reverse onus is a rule of law that places the burden on the accused to prove that something is more likely than not to be true. This is contrary to a long-standing and fundamental principle of criminal law, namely that the prosecution bears the burden of proving guilt beyond a reasonable doubt. It is also, Mr. Speaker, it is also contrary to the presumption of innocence as enshrined in our Charter of Rights and Freedoms. Under these normal rules of criminal law, the fact that the prosecution has to prove guilt beyond a reasonable doubt means that the accused, to be acquitted, needs only to raise a reasonable doubt about their guilt. A reverse onus, Mr. Speaker, by contrast, says the accused must do more than raise a reasonable doubt. He or she must convince the judge or jury that it's more likely than not that they are innocent. There are special circumstances, Mr. Speaker, in which the burden can be reversed, such as when an accused raises the special defense of mental disorder. This burden is reversed because mental disorder is really a question of what is happening inside the mind of the accused, information to which they have the best access, and it is also a defense that can be easily feigned. Absent compelling reasons, the burden must always be with the prosecution, Mr. Speaker. Yet it seems that in 1953-54 consolidation of the Criminal Code, a reverse onus was in fact introduced into numerous offenses, defenses, and evidentiary presumptions. These, Mr. Speaker, have remained in the law until the present time, with the exception of a number that have been challenged on the Charter as violating the presumption of innocence. Most such challenges have resulted in the courts finding the reverse onuses to be unconstitutional. Mr. Speaker, Bill C-51 will remove the reverse onuses that have been struck down, and it would remove all the others that, while they have not yet been subject to challenge, do not appear, Mr. Speaker, to have any meaningful justification. These changes would not have a negative effect on public safety, would better reflect long-standing principles of criminal law, would eliminate the potential for new charter challenges, and would thereby avoid the need for accused persons, prosecution services, and courts to waste precious time and resources examining these provisions. Mr. Speaker, the consensus view amongst legal professionals and associations is that these amendments form part of the kind of reforms that our criminal justice system needs to work more effectively and efficiently. Other types of amendments that may not generate a lot of attention, Mr. Speaker, but are still important include the proposed repeal of a number of offenses in the criminal code that were enacted long ago. In many cases, Mr. Speaker, more than 100 years ago, many of these offenses reflect forms of conduct or values that are no longer relevant to our society. For example, Bill C-51 would repeal offenses such as alarming Her Majesty, Section 49, challenging someone to a duel, Section 71, and blasphemous libel, Section 296. Another example of an offense to be repealed is one related to making or publishing what are called crime comics, which are exactly what they sound like, namely graphic depictions of criminal activity and violence. While there once was a time where great public concern was had for the potential of these materials or to corrupt children, for example, those days are long past, Mr. Speaker. While not everyone will support this type of material or entertainment, we no longer believe, as a society, that people should be labeled as criminals for making it. Mr. Speaker, there are also offenses in our criminal code that are overly specific and duplicate other offenses that are more general in nature. A number of these would be repealed as well. A good example, Mr. Speaker, is the proposed repeal of Section 365, pretending of practice witchcraft, as was mentioned earlier by my colleague across the floor. Section 365 makes it an offense to fraudulently pretend to exercise or use any sort of conjurations, tell fortune, or pretend to use one's skill or knowledge of an occult or a crafty science to find lost or stolen goods. This conduct is really just a small subset of fraud. Fraud involves some kind of deception or dishonesty combined with a risk of economic loss to another person. Fraud, Mr. Speaker, can occur in an infinite variety of circumstances. There is mortgage fraud, home renovation fraud, health insurance fraud, securities fraud, and basically any other situation in which a person voluntarily gives over money in response to something deceptive or dishonest. Also amounts, in fact, to fraud. There is no good reason to have offenses in the criminal code that spell out fraud, looks like in each of these circumstances, one offense of fraud gets the job done and in fact is defined within Bill C-51. Archaic offenses, such as those that overly be specific and duplicative offenses, take many pages in the criminal code. Mr. Speaker, I know that some commentators might consider these reforms the parts of Bill C-51 that do not get headlines or generate passionate presentations before committee are of little importance. But in fact, Mr. Speaker, I take a different view. We should not underestimate the importance of this kind of reform. The criminal code is a reflection of Canadian values and what we as a society deem to be blameworthy conduct deserving punishment and denunciation. It is, to be clear, Mr. Speaker, the moral code of our society, and it is our job as legislators in this House to ensure that this code reflects our current values, current priorities, and that it does not overreach, and to be rational and orderly. Mr. Speaker, in conclusion, I support the Minister and our government in undertaking this routine but vitally important maintenance and updating of our criminal code to make it clearer, more accessible to Canadians, more relevant and modern, and more consistent with our human rights and freedoms. Thank you, Mr. Speaker.